Okay. Hello, everyone. Okay. Good evening. So we'll continue with few cases from Supreme Court. Okay. Again, we have 3 cases today. All these are decided by Supreme Court of India. All of these are of the year 2021. Okay, like last few months of 2021. So these cases are related to like different areas. First one that we have is related to will. Okay, so what is a will? Anybody? Will?
It's a statement that states where all your property will, to whom all your property goes after your death.
All right. To whom property will go after death. Document that tells how to dispose of property after death. Okay, so is it that I can include all the properties in a will? Like there are 2 types of properties, right? Ancestral property and self-acquired property. Is it that everything I can mention there, or how is it? All the properties. Okay, fine. So we'll see and discuss this case today. Okay, it is related to revocation of will. The case is Badrilal versus Suresh. Okay, now if you see, there are certain, okay, so if you see, there will be certain cases like the one we discussed in the last class. I'll just open that and show you. Okay, so why is it that in certain cases we see like the state being versus state of Bihar, and in today's case it's just 2 persons, one versus the other? State usually comes in criminal cases, but will is a civil case. Correct, will is a civil case. So this case is Badrilal versus Suresh. It was decided on 28th of October 2021. Cases relating to revocation of will. So this case was decided by Supreme Court of India. Usually when you read a certain case from Indian Kanun, you get name of the court as well, whether it was Supreme Court of India or it was some high court. That details as well you get. So this case was decided by 2 judges bench, and it is a civil appeal. Number also you get to see there. Okay, now this is arising out of special leave petition, SLP as in special leave petition, civil number, this of 2019. Now it's just one case, right? Why do we have 2 different numbers? Can anyone guess? SLP means special leave to appeal, a special leave petition basically. Why do we have 2 different numbers for one single case? Was it appealed twice? Okay, so what happened, right? Special leave petition, you get a provision in Constitution actually when you study this. If or respective High Court did not give permission. Yes, correct. Vidya, correct. You are right. When the respective High Court do not give permission for appearing in Supreme Court, then this provision comes into existence, SLP. Special leave petition or special leave to appeal. They would file the case. Correct. So usually what happens is when parties file a case in the High Court, and when the case is decided by High Court would usually certify Okay, some certificate will be issued by High Court, wherein High Court would say that this is the decision, and if parties are willing, okay, if either of the parties are willing, they are free to even go to the High Court. If they are not happy with this decision, they are free to go to the Supreme Court. Sorry, High Court would say if either of the parties are not happy with the decision, they are free to go to the Supreme Court. Okay, High Court itself is saying why? Because this case involves like a very important question of law or a very important thing. That's how they would certify. So if High Court itself is certifying, there is no problem. Parties can go and file an appeal. But sometimes High Court will not certify. High Court would be like, okay, this matter is not having any importance. We are not certifying it. Okay, Supreme Court should not be wasting their time. But even when High Court has not certified, parties can still go to the Supreme Court, but they cannot directly file an appeal. They need to file special leave petition. Okay, like appeals would usually be heard by like a division bench, but special leave petition is just one judge before whom they need to like prove their point that this is an important matter and you should be entertaining an appeal. So Supreme Court would see whether this special leave petition is of that much of importance or not. If yes, they would entertain. They would be like, okay, SLP is allowed. You can just file the appeal. Okay, that's why we have seen two different numbers here. In 2019, not like waste their time. Like this is, it would be like decided very quickly, okay, and there is just one judge sitting there. Rather than wasting two judges time and everything, it is considered as important because not like too many, yeah, SLPs are filed by many people many times, but it can be, like decided very quickly. There are many times when, like the High Court feels that no, it's not important matter, we are not certified, but still it may have an important value. Many of the cases, by way of SLP, parties approach the court, and then Supreme Court has actually given a very, like an important decision, like a landmark decision also. So even though it is taking some time of one judge, that is worth it, right? Like this case, but then everyone who has not succeeded with High Court would go for SLP and make High Court's authority weaker. Not like High Court's authority would be weaker or something, but yeah, like we at the end we want to provide justice to the people, right? They also should not be suffering just because High Court feels this matter is not of that much of importance or authority. Like we have seen that national anthem case also, such a landmark decision was given by Supreme Court, but then Kerala High Court felt that it's not of that much of importance. They did not certify it, but by way of special leave to appeal only, the parties, the father approached the Supreme Court. So sometimes it definitely, actually most of the cases which I have heard, High Court will be revoked by. Given by Supreme Court. Okay, yeah, there are cases where it may be revoked also if Supreme Court is not satisfied with the decision. Okay, like I think here only we have one case today itself where High Court's decision was not accepted by Supreme Court. But that again depends on how facts are presented, how evidences are given, and all those things, right? How the case was decided at the lower court. So fine, this case is relating to will and it was filed before the Supreme Court. Now what has happened here, we will see that. Okay, so the Supreme Court has held that a will cannot be revoked. Now, what is revocation of will? As in, a person has prepared a will wherein he has mentioned how his properties would be divided, right, amongst different people, how his properties would be divided. That is nothing but a will. What is revocation? Officially cancelled. Removal, yes. So revocation as in removal or cancelling the will which is being prepared. So what Supreme Court held is that A will cannot be revoked by an agreement, and it can be revoked only as per the models which are specified under the Indian Succession Act. That means once a will is prepared, because there is no time limit as such, there is no like age group that a person only above 70 years, 80 years can prepare a will, right? We don't have any such limitation. Anybody can prepare it. That's why it's also free for parties to make changes there, because a person may prepare a will today and he may feel like, no, I want to make some changes in my will. That's why revocation is allowed, but it cannot be the way parties feel like, but it has to be based on the modes which are specified in Indian Succession Act. Okay, so it cannot be revoked by an agreement, because that is not a mode which is mentioned under Section 70 of Indian Succession Act. In this case, Badrilal versus Suresh, Supreme Court said that by agreement it cannot be decided, and this bench gave the decision. Now, when we talk about property, like law, right? Law always like approve on this thing that property should not remain with one single person. Okay, it's always good for the society that property keeps moving from one person to another, from another to another. So law always prefers transfer of property, moving property from one person to another for under various modes, various reasons, various grounds. Why? Because that will enable the government to earn some revenue, right? When a property is registered, that is a lot of money that needs to be paid, right? And also it will ensure that property is in use. It's not like just lying there, nobody is using it. So transfer of property is very much given importance by law, and it may be transferred by two ways. Okay, it may be transferred by act of parties or by operation of law. Can you guess what is the difference between these two modes? From the name, can you guess? Act of parties, and here it is operation of law, like application of some law. Act of parties means someone transfers the property. Act of parties, yes, correct. So act of parties is nothing but willingly, by doing some act, parties have decided to transfer the property. And operation of law means it like the party had no option, some law became applicable and the party had to transfer. So if there is not a will, does the law get involved? Yes, if there is no will, then based on the laws, it will be divided amongst the legal heirs, how property would be transmitted to people, like transferred to different people. If there is no legal heir, does the government seize it? Yeah, if there is no person to claim it, if there is nothing, no one will go as per the personal succession. Okay, we have different laws actually. This Indian Succession Act, right? This is applicable for this all the other communities like Hindus, Jains, Sikhs, Christians, etc. For Muslims, again, they have their own personal laws as well. Okay, so who was taking care of the person? Maybe that person would want to claim it, or something would happen to the property at the end of the day. Okay, because it's not just like family members, there are a lot of classifications mentioned who would be, like based on who would acquire the property, right? We have like a long list of people, so someone or the other one would get the property. So when we talk about act of parties, right, it may be testamentary or non-testamentary, as in when a person is living, at that point in time only he can transfer it, or it may be once the person dies, after that property will be transferred, like by way of will. Even if a person writes a will, technically it's like when he is alive, that time only he is preparing it, but it will be executed only when he dies. So it is called as testamentary. Non-testamentary, as in from living to living person, they are transferring. It may be by way of sale. Any other mode you can mention how property can be transferred between two living persons?
Gift deed.
Gift, yes, gift deed. Anything else? There are so many other also, right? Lease is there, exchange is there, then we have mortgage. Okay, there are many different modes under which it may be done. And when we say operation of law, some law became applicable, like Land Acquisition Act, UP Jamindari Abolition Act, Kerala Land Reforms Act, Punjab Land Reforms Act, Bihar Land Reforms Act, and for that we have multiple cases also. Golaknath case, Sankare Prasad, Keshwananda Bharati, all these cases coming from this land reform or Jamindari abolition laws only. So this is nothing but operation of law, because some law became applicable, property got transferred. Right. So for this case,
And what about foreclosure of houses? Like if they fail to pay the loan, does
yeah,
that come under the law? Like
that actually is like between living person there is mortgage, and in the mortgage itself there will be a clause that if you fail to repay the amount, then this is how foreclosure would happen. So that would be like under this only, right? Because two living persons are entering into this mortgage deed, and there only some provision is there whereby property can be uh, taken by a person. Okay, so here also, even if we are not saying like operation of law, it's here also like transfer of property act applies, right? So laws are obviously there even here. So for this case, this part is important, which is nothing but testamentary succession, whereby by way of a will property gets transferred. Now, what is a will? That is defined under Indian Succession Act also, which says it's a legal declaration of the intention of testator. The one who is writing or preparing the will, he is called as testator. So testator with respect to his property, which he desires to be carried into effect after his death. After his death, how property will be divided, between whom it will be divided, he will write it. So this is nothing but like a legal declaration. And once a person has prepared a will, after that also the person may feel like, no, I want to make some changes in this will. I want to make some amendments over here. For that, we have another word which is called as codicil. Codicil is defined in section 2B of Indian Succession Act, which is nothing but an instrument made in relation to a will and explaining, altering, or adding to its dispositions, and shall be deemed to form a part of the will. Will is prepared. After that, maybe parties feel like this is not being very clear. Okay, it's not very clearly like explaining how property should be divided. So in that case, they may need to add some additional explanations, or they may want to make some alterations, addition of someone's name, right? All those things may be done by way of a codicil, like a subsequent document which is there. This happened in case of contracts also. Okay, parties may enter into a contract. After that, they want to make some changes or additions in the contract. So there will be like another document under which it will be done. Same ways here also, some changes they want to make means they can do like this. Now, when we talk about properties, it may be self-acquired property or it may be something which a person has inherited. So for self-acquired property, we can decide who will get this property, to whom this property should go after our death. And this law would apply to Hindu, Sikh, Jain, Buddhist, and Christian. For Muslim, we have like their own laws, where legal heirs are actually given more importance. Okay, for these communities, they are free to decide to whom property would go. They can say that I want to give the 100% of this property to some third person, to some random stranger. They can give it. But in case of Muslim, right, there is a limitation basically which says only up to 1/3 of the property he can give to a third person. Okay, if he wants to give to some stranger at all, some third person, he can only give up to 1/3 of his property. At least 2/3 should go to the legal heirs. Those people it should be going. So that is like a difference in terms of Muslim law, wherein legal heirs are given much more preference as compared to these other laws. Okay, but that does not mean like a Muslim cannot give his property to a random stranger. They can also give, but they can give by way of gift. Okay, it cannot be by way of will. He cannot say after my death 100% of my property would go to so and so person. After that, this limitation would apply. Only 1/3 of his property can go. So there are differences in terms of the personal laws which apply. Okay, now this Indian Succession Act. Yeah, if he is alive, he can, if like he wants to give to a third party at all, he can give it to a third person by way of gift, but he cannot say after my death it will go to a third person. Only 1/3 of it can go to a third person after his death. Once he is alive, he can gift it. No limit, no problem over there. Yeah, when he is alive, he can give 100% of it also. Okay, but for self-acquired property. Okay, now Indian Succession Act, it makes provision for writing of will and also makes provision regarding alteration or changes. How alterations can be made, for that also provisions are there. So those provisions are mentioned in section 70 of the legislation. Okay, it says revocation can be done by either of these three modes only. If a person has prepared a will, he may prepare another will. Okay, execution of another will or codicil. He may make changes. He can prepare a codicil or he can prepare like a completely new will altogether. It may be a writing executed by the testator declaring an intention to revoke the will and executed in the manner. So he may say that I want to revoke this will. I prepared one will, but I want to revoke this will. Or he may, what he can do is he can burn it, he can tear it, or he can destroy this will. Okay, he can destroy it or he can instruct someone to destroy it with the intention of revoking it, because he do not want to want it to be valid, right? He can destroy it as well, and that's how revocation of will can be done. These are the permitted modes or methods. Yeah, codicil is like a new document which is prepared in relation to the will, that in this certain will we are making these alterations, correct? Okay, so these modes are prescribed in the Indian Succession Act. So in this particular case which we are discussing, what happened is that a will was prepared and at a later stage. So a will was prepared, there was some properties got distributed amongst few people. Okay, at a later stage, what happened is there was an agreement. Agreement was made by the testator with another person, and based on this agreement, what they did is they promises to allocate property to another person. Based on the agreement, there were certain changes which were made. In terms of the will, property was given to someone, but based on a subsequent agreement, they made some changes over there regarding allocation of property. But this agreement which was there, it was just like an agreement that like they have entered, and it was not even like a registered one. It was not a codicil. Okay, it was just an agreement between two persons, the testator and another one. So it is not even a sale deed which was executed by either of the parties. just an agreement. So this agreement to purports to record how the property of testator will revolve after his death. Therefore, this agreement will not have effect of transferring property to the parties mentioned, because there already was a will that was in existence, and it was not like the property got sold, the property was registered in name of the person or something. That did not happen. It was just an agreement which was not even registered. It just made some changes in terms of the will. So court said that this is not how you can make changes in a will. Right? For will, we already have an established law, Indian Succession Act, and that law will be applicable. Based on the provisions of that law, a will was prepared by the testator. So at the later stage, if they want to make any changes, they need to stick to section 70 of Indian Succession Act, and that's how the revocation or changes would happen. There was no codicil, no proper rules were being followed, and just with the help of an agreement made between the testator and someone else, that would not have the effect of making changes in the will, right? So will was considered as valid, and it was said that this is not how it will happen basically. Okay, so Badrilal versus Suresh, because this property got transferred to like few people. You can even read this facts of the case. It has all the details, how it was prepared, amongst whom, how much of property got transferred, and what the agreement laid down, and how this person started claiming the property, and then dispute arose, and then case was filed, and finally this is how it happened. So whenever we have an established law, that law needs to be followed, because already mode of revocation and everything is specified. That should be followed, and that's how the will can be revoked, changes may be made over there. Is this case clear? Okay. Next one we have is related to check. Okay, so have you seen that there are certain situations wherein a blank check will be issued? Have you seen that? Blank check, or might be the amount will be mentioned, but like okay, in movies, yeah, correct, blank check usually in movies, right? How much money you need to do this, here is a blank check, not that ways, but yeah. Have you seen like a blank, not like a blank check, it may be blank check, or it may be that amount is being mentioned, check given like a security, okay, just so that you can like trust my words, I'm giving you a check as a security. Have you seen that in any case, any situation? Maybe while someone opts for a loan in the bank or something, like a collateral, or even in case of this one, like a bond agreement. If there is a bond agreement between the employer and employee, okay, you have not seen, yeah, sort of collateral, you can say. Okay, this case is related to check as security. That means check was issued as a security, that you can trust my words, that's why I'm giving you a check. Okay, so now, like I mentioned, where have you seen? Take for example, I have seen it in two cases. Okay, first one is that in a job. First one is that in a job, what happens, right? In many of the jobs, candidates are asked to sign on bond agreement. Okay, candidates are asked to sign on bond agreements. They will be said that we are like providing you some training, we are investing some money, so we want you to work in our organization at least for 2 years. Okay, just an example. There is an agreement which is signed by the employee wherein he promises that at least for 2 years employee will work in the organization. That is the condition. But if employee leaves the organization before 2 years, okay, if employee resigns the organization before 2 years, employee needs to pay 3 lakh rupees as compensation. All right, now employee may feel like, okay, fine, I will join the job today and I will complete my training and everything and I will leave the job. Who is asking anyways? It's online, right? I will leave the job. No one is there to question me. They might feel like that. Okay, so just in order to make this situation look a little more serious, okay, just to ensure that this candidate is serious while making this promise, what company will do, right? Company will ask the candidate that you need to give us a check. Okay, you need to give us a check of your concerned bank account amounting rupees 3 lakhs. You need not mention any date. Okay, no date will be mentioned. You need to issue a check. Amount will be mentioned as 3 lakhs. You need to put your signature and you need to deposit. Okay, you need to what you need to do is you need to deposit this check to the company. In that case, the candidate will think twice before signing on this bond agreement, will think 5 times before resigning without before completion of 2 years then, right? So that is one very common situation wherein companies will ask that you need to provide us this check. In very rare cases only companies would actually claim this money. Most of the times companies would be like, okay, fine, even if he is leaving, they would just like ignore it. In some cases companies may actually file the case or like claim for the money, like deposit the check also. That is one situation. Another situation is wherein you apply for a loan. Okay, wherein you apply for a loan. Take for example, I have seen this wherein, take for example, you approached a bank. Okay, you approached a bank to apply for a loan of maybe 40 lakhs rupees because you have bought a maybe flat. Okay, you have bought a flat, you have bought an apartment, and amount is 40 lakhs rupees. For that, you went to the bank and you applied for loan. When you apply for loan for property, your flat or your land, that is on mortgage. Okay, bank will take mortgage of it. Bank will keep all the original documents and everything so that you cannot sell the property to someone. All right, so it is already in mortgage. Along with this, even if the property is mortgaged, along with that, what bank will do is bank will say you deposit some checks to us. Okay, you deposit some blank check. Amount is not mentioned, but you need to put your signature. You should not be mentioning any dates and you give it to us. Okay, and bank will keep it along with them until and unless you clear this loan amount. Till that point, bank will take it with them. So these, what happens, right? If at point you are in a position where you are not returning the loan amount, bank will deposit those checks, right? Bank will mention an amount, bank will deposit the check and will recover the money. This is a quicker process rather than they filing a case to like get the property on mortgage, right? Foreclosure and everything. If they misuse it, usually again this trust factor would be there. You usually like take it in writing also, that like some numbers would be given, right, in a check. So you would mention that these check numbers, 12 numbers, 10 numbers, 13 numbers of check I have given to this bank. So bank number and all will be mentioned, right? So you have signed on an agreement. if that certain check was like deposited by someone, misuse or whatever, you have the agreement with you, so you can, like, legally speaking, you can file a case to recover it. So that's how it works. You have an agreement with the bank as well, wherein it's mentioned very clearly along with the check number and everything. Okay, so these are the two situations. And why this check is taken is because even if you are not having enough money in your bank account, the check is dishonored, it becomes a criminal offense. Okay, if you have enough money, bank is able to recover, the process is very much fast, bank will easily be able to recover the money. If not, also it becomes a criminal offense. Okay, you can be held liable for imprisonment, punishment, everything. But if the property was on mortgage, they would file for debt recovery tribunal, case would be filed, they civil, it will take a lot of time, lengthy process. That's why banks will also take checks. Okay, that's the reason why it is taken. So these are two situations. First one is job, second one is loan. These are two situations wherein bank may take a check as security, right? Bank is not taking the check that, okay, today you give the check, tomorrow I'm depositing it, but bank is taking it as a security, just in case you are not returning, we have an option. Okay, that is the thing. Now what happened in this case? Sripati Singh versus state of Jharkhand. All right, and when this check is given as a security, okay, it may look like, oh, it's just a formality and everything, but there still is a possibility. The situation may arise wherein bank or this employer may actually need to deposit the check also. Okay, so it's not just like a formality. Sometimes parties may approach the bank and deposit the check and demand for the money also. All right, so this case is Sripati Singh versus State of Jharkhand. It was decided on 28th of October 2021. Actually, the same date like the previous case. Okay, now what happened in this case, we will see. This part understood, right? So security thing.
Yes, ma'am.
Okay, now what happened here is Sripati Singh and respondent number 2. Not that important to know the parties and everything. Just know that there were two parties. Okay, the appellant over here, Sripati Singh, plus respondent number 2. Both of them knew each other. Okay, they knew each other, and their daughters, right? They were studying in London, like the same university they were studying, so they both knew each other. So these kids completed education, and then they decided to return to India. So they studied there together, they returned to India. After that, what happened is respondent number 2 settled in Bangalore, and because they were already known to each other, they were maintaining that relation in a good way. Okay, so this happened. After some time, respondent number 2 came to know that this person, right, this person is involved in a business. All right, so this person is involved in a business. So respondent number 2 approached him and asked for some sort of financial assistance. Okay, he's asked for some financial assistance, and he said that, can you please give like 1 crore rupees to me so that I can invest in my business, I can start my business. Because they were already known to each other, and this other person also promised that I will be returning you this amount as well, so you give me the amount. So he gave 1 crore rupees. After that, again he demanded for money, again he gave, so total 2 crores was given during this period. Okay, January 2014 to July 2014. During this period, this person gave 2 crores to respondent number 2's kid for the purpose of investing in business, because he wanted to start a business. Now, for this same transaction, what happened is that I have given 2 crores rupees to this person during this time. They entered in agreements. Okay, some agreement was there in writing wherein they mention that, yes, I have received this loan amount of 2 crores from so and so person and everything. Okay. And 3 checks were given. Okay. 3 checks of different amount, total amounting 1 crore rupees was given to the appellant, as in Shripati Singh. Right? Because Shripati Singh has given 2 crore rupees. So as a security, 1 crore rupees, total 1 crore rupees, 3 checks were given as a security. Okay, so what happened is that during July 2015, it was supposed to be returned, that I will be returning you the money, right? This until July 2014 money was taken, and then it was said that July 2015, after a year, I will be returning you the money. So after 1 year, this appellant, right, Shripati, met this respondent number 2 and asked for the money that you have given this check. So should I be depositing it or not? Respondent number 2 said that no, I need some more time. By October 2015, I will be returning you the amount. Okay, so he said that I will be returning by October 2015. Already 3 checks were there with Shripati, right? So Shripati, what did is, without asking respondent number 2, on 2010-2015, that is in October 2015, he deposited those checks in the bank because it was promised October 2015 it will be returned, right? So the check was deposited in the bank. Now respondent number 2 was under an impression that I'm just giving this check for the purpose of security and it will not be deposited. Maybe it will not be deposited by Shripati, right? So the check was deposited on this date, and after that what happened is, check was not cleared. It was returned by the bank mentioning insufficiency of fund in bank account of respondent number 2. Respondent number 2 is not having that much of money in his bank account, so checks cannot be cleared. It was returned to Shripati. And when a check is dishonored, it is an offense under section 138 Negotiable Instruments Act. And for Negotiable Instruments Act, we cannot like directly file a case. Okay, you cannot directly file the case. Today check is dishonored, tomorrow you are filing a case. It does not happen that way, but you need to serve some legal notice and stuff. Some formalities are there. So Shripati also followed those formalities. Legal notice was served and everything happened. Okay. Now respondent number two had taken the money on the assurance that it will be returned, but he did not return the money, right? So this Shripati thought that this is like a case will be filed because legal notice was also not answered. So he filed a case under section 420, cheating, and section 138, check bounce. Under these 2 sections, case was filed. All right. And while entertaining the case, court said that it does not fall under section 420 basically, because maybe there was no intention to cheat as such, right? Party may not be actually having the money to return it. So in every single case where it's check bounce, we should not be just straight away adding 420 also. We need to look at the situation and everything. But yes, under section 138, there is a valid case, and that case was, it was considered as well by the court. So in such cases, wherein check is given as a security, like I mentioned in these 2 cases, the party cannot assume that my check will never be deposited. It is just like a formality. It is a formality. It may be a formality, but in case the check is deposited and it's dishonored, party cannot simply escape. It becomes a criminal offense, wherein the person may even go to jail for up to 2 years, or may be fined for, like twice the amount of money. He may be fined also. So even when a check is deposited just as a security, the person need to be very careful with this regards, because it may attract criminal provisions against the person as well. Okay, is it clear? in the end, the person was held responsible for section 138 of Negotiable Instruments Act, but this 420, right, that part was like removed by Supreme Court. Supreme Court said that he is not responsible for that part, but this other part he is responsible. Actually, what happened, right, in this case, first the case was filed in magistrate court, wherein magistrate court had said that yes, the person is responsible only under section 138 and punishment was given. But then case went to high court. High court said person is responsible under both section 420 and 138. After that it went to Supreme Court, and Supreme Court said that no, like lower court was right, magistrate court was right, person is only responsible under section 138. So actually that order of lower court, it was not I could not extract that order. Basically I got the court name and everything, but that order I could not extract. So there only this punishment is given. What was the punishment or what was the fine imposed, that's given in the lower court's order, which I could not like extract. So I don't know as such what was the exact order passed by magistrate court, but yes, the liability, right, liability was under this section only. Sometimes it happens that even in lower courts, right, case may be filed and then the details are not even uploaded. Sometimes order is not uploaded. Okay, so sometimes you may not get the order copies, judgments copies, everything might not be available, and same happened with this case also. Lower court details could not be extracted. Okay, but even like what was the punishment, that's one thing, but another important thing is we need to know this principle that even if check is deposited as a security, it may like attract criminal provisions as well. So that's also important. You can even, or you can also try to get the details. Like I said, right, this case you can simply search, you will get details of the lower court case also, and you can also try to figure out if you are able to find the order or not. If yes, it's well and good, right? You can read that for yourself. You can note down this part to see for lower court details. Okay, next, another thing we have is another case of Supreme Court of India. Okay, V. Nagarajan versus SKS Ispat and Power Limited. It is a case which was decided on 22nd of October 2021. Okay, this again is a civil appeal. Now, for this case, it becomes very important for us to understand these three things. So what is limitation period? Anyone wants to answer? So this is plaintiff is dead, so his son was taking care of this case. Actually, it's mentioned there that son was like representing the deceased. What is limitation period? Anyone wants to answer? Deadline. Yes, it is deadline. Deadline for filing a case, right? Deadline to approach the court, right? Whenever something happens, if we are a victim or we want to like approach the court for something, there is a limitation period which is fixed. Within this time frame we should be going, and that limitation period would vary based on different cases. Okay, so limitation period is fixed by this legislation, which is called Limitation Act 1963. that mentions that within this duration, you should be going to the court claiming your rights. Apart from this also, when you are reading other legislations, other statutes, right, you will see that sometimes the legislation itself would say that, okay, you can file an appeal, but within 30 days, within 90 days, within 60 days, like that. In the legislation also, limitation may be mentioned. So whatever is the limitation, we need to follow that limitation. Okay, so that's the general rule, that there is a certain time frame mentioned. Within that, we need to approach the court. So what do you feel is the reason of putting such a time frame? Why can't we have this option of going to the court whenever we feel like? Why a limited period is given to us? What do you feel might be the reason? Because otherwise some people will dig up yeah, some people will dig up 100-year-old cases. Correct. Evidences will be erased. Can they mess with evidences? Yes. And also witnesses would forget, right, what happened. Because if someone is asked that, okay, fine, did you see this accident taking place? The person would say yes. What color the car was? How did the person look? All those things the witnesses would forget with time, right? So that is very important, that there is a limitation period so that evidences are available, witnesses can remember the things, and it makes sense, right? Why to wait for 10 years when you can file the case within 3 years? That's why we have limitation period. Now, even though there is a limitation period, we have a law related to it. There is a situation wherein court can be like, okay, fine, even if it's delayed, fine, right, we can excuse it. Okay, that is called as condonation of delay. Even though there is a delay, parties can, like, pray before the court for condonation of delay. They can file an application that because of this reason it got delayed, and if the reason is valid enough, strong enough, court may even entertain the matter after the limitation period also. Okay, even if limitation period is over, court may be like, okay, fine, you can file the case. Okay, like because of COVID, there was nationwide wise lockdown, so I could not approach the court. It's a valid enough reason, right? Court may allow the parties like that, they can file. So this is what is important, that parties can file an application for condonation of delay as well. Now, just like how I mentioned, for some legislations, like a legislation itself may mention some kind of a time frame. Same ways, we have a legislation called Insolvency and Bankruptcy Code of 1961. Okay, in this legislation, it mentions that we have 30 days of time frame. Okay, we have 30 days of time frame to file an appeal. Okay, and in some cases, right, court may even allow also, like after time frame is over, after that also court may allow. Now there are actually two bodies. One is called as National Company Law Tribunal, and another one is called as National Company Law Appellate Tribunal. So if you are not happy with decision given by NCLT, you can approach CLAT and you can appeal there, but within 30 days. Okay, in this case, what happened is the time frame was already over, 30 days time frame was already over, and party filed an appeal. And the excuse that they gave was that, like, this is the website, basically you can visit it also if you are interested. Okay, you can visit this website and see what is it. Basically, whatever decisions they are taking, providing, right, NCLT or CLAT, they will be updating it on their website also. It will see the orders and everything. All right, so what happened when this matter was filed before NCLT, National Company Law Tribunal, they passed an order. Okay, so obviously order will be passed and parties also would have an idea that this case is disposed, order is passed and everything. So it does not matter that much whether the order was uploaded on the website or not, on the online portal, whether it was updated or not, that does not matter. When limitation period would start? Limitation period will start from the date when order is pronounced. Right? If today order is given 9/1/2022, limitation period would start from today. Even if order was uploaded on the website maybe 10 days later, it does not count from that day. So in this case, party said that because there was delay in uploading the order, from that day I'm counting the limitation period, and that's how I should be allowed to file the case, because there was delay from the NCLT side. So in this case, it was said that no, you cannot say that because there was delay from uploading the order. From there, it does not count. It counts from the time order was passed. Okay, so within 30 days, ideally we should be filing the appeal before this tribunal, NCLAT. But if NCLAT is satisfied, they may allow an appeal to be filed after expiry of 30 days period, only if they are satisfied. Okay, but we cannot say that because of that delay that we cannot seek condonation, because limitation period already started. So if party failed to approach the court within 30 days of time frame, he cannot file a case for fixation extension in this period. He cannot say that, okay, just make changes in this 30 days period because it took time for them to upload the decision or something. Okay, NCLAT is free to take a decision whether they want to accept this condonation of delay application or not, because it is under their sole discretion. Right? It also mentions the National Company Law Appellate Tribunal may allow. They are not bound to allow, but they may allow if they are convinced that you had a valid reason. So that is what was said, that this limitation period is very much important. It is of very much relevance. Whenever a legislation fixes limitation period, we should try to stick to it. If we fail to stick to that, yeah, law may have a provision wherein you can file condonation, but that is not your right. That is a discretion of the judicial body. Whether it's a tribunal, it's the regular court, it will be their discretion. If they can want to allow, they can allow. If not, you don't have the option. You cannot say that make changes in this limitation period because there was delay from the side of tribunal in uploading the order. Right? So it shall be 30 days within which they need to file the appeal, if at all they want to appeal before NCLAT. Is it clear? So NCLAT is free to take a decision for condonation. Same thing you would see in case of regular courts also, plus you will see in case of legislations like RTI, Right to Information Act. There also you will see there are two provisions of filing appeal, first appeal and second appeal. There also some limitation period is there, some 30 days, and second appeal, I guess 90 days, like that limitation period is there. So once limitation is over, you can just file an application for condonation, but that is discretion of the body. Okay, it is not your right, but it is discretion of that body whether they want to allow it or they do not want to allow it. So fine, then these were the three cases decided by Supreme Court. All the cases are from October 2021. Okay. So fine, if everything is clear, we'll end this class here then. Okay, thank you everyone.